My name is Heather Sanford, and I'm the moderator for this last of the sessions, the full panels, which is called The Law and Practitioners' Perspectives. What are the challenges in representing whistleblowers? I'm a relatively new member of the board of Whistleblowing Canada Research Society. I'm a non-practicing member of the board of the bar in Nova Scotia. And my relevant experience in this arena is not as a practitioner, but as a whistleblower. So it's been really interesting the last day and a half to listen. I would say that my expectations or my experience as a whistleblower have been very consistent with that of others. It's an eye-opening experience. It's a depressing experience. It's isolating, and it can be absolutely infuriating. I do think, though, that rightly or wrongly, having background as a lawyer and having practiced law does make you a little bit better able to navigate that experience and perhaps come out of it in reasonable shape, professionally and personally. Because not only as a lawyer can you understand your own rights and think a bit about your own rights as you're going through that experience, and you can navigate and understand the law and push a little bit where you need to push. But I think lawyers spend a fair bit of time managing expectations, and being able to manage my own expectations and maybe being a bit cynical and having some low expectations helps a lot, I think, in just how you come through that experience. Sadly, low expectations. I would say that sadly, my low expectations were met in terms of justice or how these things sometimes play out. But we'll be a little more optimistic. I'm very pleased today that we have access to 4 practicing lawyers who practice in a variety of different ways and come at the whistleblowing experience from different angles. And like a lot of these panels, I think we're in 4 or 5 different time zones. Carolyn, I think, is usually in Geneva, but I think maybe somewhere in Egypt today. Kelly VanBuskirk is in St. John, New Brunswick. Paul Champ is in Ottawa, Ontario. Paul Jaffe is North Shore, Vancouver in BC. I'm in northern BC, in Prince George, on the traditional territories, the beautiful traditional territories of the Lheidli T'enneh in Prince George. I'm not going to spend time introducing everyone. I'd like to jump right in. I do want to make sure we make the most of the time that we have to have access to the insight and the expertise and some of the practical knowledge that each of these practitioners can bring to us. I'd welcome you'd be welcome to make a few introductory remarks yourselves as we work through each of the panelists. We'll do a round we thought of about 10 minutes for each person, and then we'll loop back through each of the panelists and allow them or give them a chance to pick up on or comment on things that other panelists have said, and then we'll go to the Q&A. Probably by this point, most of the attendees have attended other sessions, so you'll know that the chat function is also open. But if you have a question that you'd like to have answered or for all the panelists to see, please post that in the Q&A. And I'd like to start off, I think, with Paul Champ, if that's okay.
Sure. Thank you very much, Heather. And I want to thank the organizers of this great conference. I've been following and involved in whistleblowing law for close to 20 years. And I wish I could say it's getting better and easier for whistleblowers, but I can't say that honestly, unfortunately. I am, for those who don't know me, I'm a labor and employment lawyer in Ottawa, and I've represented a large number of whistleblowers over the years in policing, public sector, municipal sector, education, and the private sector. And I think I can speak to some of the themes that I've encountered in litigating these kinds of cases and representing these very special kinds of clients, because there are enormous challenges in these kinds of cases. First and foremost is when you're trying to represent someone who is a whistleblower, you are contending with an employer or an adversary that is highly motivated to basically completely wipe out your claim in every way, and motivated to litigate exhaustively and very aggressively out of proportion completely with what, any monetary value might be associated with the claim, because for the employer or the institution, these kinds of cases, it's nothing like a regular employment case, because for them it's not about money. It's about, in some way, their reputation, or covering up concerns about wrongdoing within the organization, and for these kinds of institutions or employers, protecting their reputation and keeping some information confidential is far more important than the actual claim. The second, and I'll circle back to that in a minute, but I'd say the second big theme that I encounter when I represent individuals who are whistleblowers is the individuals themselves. I'm sure there's lots of people who have been whistleblowers in the past who are following this panel, and I'm sure they won't have any difficulty when I say that people who are whistleblowers can be very difficult clients because they've gone through so much. They have by the time they've come to you, they've already gone through a really difficult process mentally and professionally. Often it's people who've had to contend with, really fundamental conflicts between, in some cases, professional obligations or ethics and their duty of loyalty to an employer. They may have been experiencing harassment for a prolonged period of time. They may be, having mental health impacts from what they've been doing. So those are those are very common features with these kinds of clients. And then the other thing is that in litigating a case or trying to resolve, like as a lawyer, I try to see myself as a problem solver, right? And if you have a client, an employment case, you want to solve the problem, either get them reinstated, or get them some sum of money in exchange for, being terminated. Usually for whistleblower type clients, it's much bigger than that. It's often consumed their lives, and it's about getting justice. And what does that mean, right? So I often find that I start becoming, in some ways, a counselor for the client, in ways that I don't, or to an extent that I don't in other cases. Often the client, and in terms of what justice means for that client, is also difficult. When I was just saying that the employer is often not motivated by money, and they'll want to litigate very aggressively and exhaustively, the client is also often not motivated by money, practically not at all in my experience. So, as a lawyer, unfortunately, in employment cases, we're very binary often, is that we're trying to achieve a very narrow type of goal for a client. And I'm sure, Kelly and some of the other lawyers will agree with me when I say is, lawyers, unfortunately, we kind of reduce a case and attach a value to it, a dollar value, because that's what we do all the time, right? And but for these kinds of clients, it's, to an extent, unlike any other client, it's not about the value at all. It's about, trying to expose the wrongdoing or being vindicated and proving they're right. And that makes it difficult to try to find other ways of resolving, because then you have these two complete oppositional forces, where the employer, the institution, wants to prove they're right, or often toss the case or aggressively litigate it no matter what, and you've got a client who wants to litigate it no matter what. You might have cases where the employer is putting money on the table because they want it to just go away, but your client wants something more. They want to be vindicated. When you get in mediation discussions, there'll be often an employer will want a very extensive non-disclosure agreement. Not often, every single time, always. Very strong gags, usually very punitive clawbacks if your client says anything at all. Often even the fact of the settlement, an employer will want even the fact that there's been a settlement to be completely confidential, where if you have someone who's usually been fighting this issue or for years, then they can't even tell people that there's been a settlement. So that makes it very difficult. And then the other aspect of these clients also is, they often don't have the resources for this long protracted battle that an employer wants to throw at them. You know, just because, you know, on its face, litigation is very expensive, you know, if you're going to go the full, you know, the full distance. Often people who are whistleblowers, they are having post-career harm sometimes. Sometimes they've been discredited by their employer in their profession. So they're having difficulty being reemployed because of the health impacts or the stress-induced health impacts. Maybe having problem being reemployed, so they just don't have much resources, and so that's a challenge to manage that. So it's these are all really major challenges in trying to advance these cases. And the last thing I'll say on it is in trying to get justice for these kinds of clients, if you can get that far and you're before a decision maker and you're leading your evidence on the wrongdoing of the employer and how your client did act appropriately and how the employer really did retaliate against the individual or your client, or there was serious act of reprisal, I find there's a real cultural problem in Canada with the decision makers, you know, whether it's a judge or whether it's a labor board or whether it's an arbitrator. And I've appeared before all of them in these kinds of cases. Canada, this is just my own personal opinion. Canada is a very elite oriented country. And I think that, you know, judges and decision makers have an aversion to finding deliberate or intentional wrongdoing by an institution or employer where, you know, it's often other elites that are implicated in the wrongdoing. You know, it's one thing to say, you know, someone's been terminated and they should have been paid 8 months and, you know, or 10 months instead of 2 months or 3 months. That's one thing. A judge or a labor board has no problem doing that. Or yet, you know, reinstating them in some other circumstances, it's not a big deal. But to find in favor of a whistleblower, you have the decision maker has to go an extra distance and say, no, this institution, you know, was potentially or was involved in serious wrongdoing and they deliberately retaliated against this individual. Those are, you know, for whatever reason, culturally, it's maybe it's impolite to say someone's like tisk tisk, you've done that, when it's one elite to another. That's my experience. So I always find those kinds of litigation battles really uphill in trying to persuade a decision maker to go, you know, to go the full way and say, yes, this was an example of reprisal. Because, you know, the reality is there's not many cases out there that are fully successful in that way for whistleblowers. And I'm sure, you know, there's a lot of people on this panel and participants who know that to be true. I was doing whistleblower cases in the federal public service before the introduction of the Public Servants Disclosure Protection Act. I've been around quite a while. And unless I'm mistaken, since 2004, with the introduction of that legislation at the federal level, there's not one single case of a finding of reprisal. Not one. There's findings in some cases where someone's disclosed something and there's an investigation by the Public Sector Integrity Commission where they found there's been wrongdoing of some kind. There's a few of those, not many. We're talking a short list there, but a finding of reprisal against the whistleblower, not one. And not just, I mean, without getting into individual cases, we just know statistically that's impossible. You know, the federal public service is like what, 250,000 people, and over 18 years, there's never been an example of reprisal. Well, we all know that's just completely wrong. That's not the case. And yet, you know, without getting to the details of all those different cases that have lost in so many different ways, it's a real struggle. Anyways, those are sort of my high level comments. I could have gotten into more details, but I know, you know, we'll have a good discussion hopefully across the session. And thank you, Heather.
Thank you, Paul. I think I just said, I've been nodding my head and saying, yes, exactly. Yes. Wow. It all rings so true. And thank you for those opening comments. And we'll move then to Paul Jaffe.
I think we got you on mute there, Paul.
There you go. I said, this is a bit like driver's ed. It's a bit like driver's ed. I can't actually manage these things, even though I'm moderating, so it feels kind of weird.
If I could count the number of times I've started to speak online while being on mute, I wouldn't have to do this kind of stuff. So much of what Paul has just discussed applies very squarely into what I'm going to address in a minute. I guess I stumbled into this arena from my fairly recent role as counsel on behalf of a couple whistleblowers who had come forward in the context of the big money laundering problem that we have out here in BC, and the use of the casinos by organized criminals to launder their money, and how the institutions of BC had failed for so many years to take meaningful steps. That failure, of course, is a function of the obvious conflict of interest between the revenues of governments and the success of the casinos, and the casinos depending very heavily on organized criminals who bring their cash there as overtly as hockey bags full of it, in plain view of people whose superficial responsibilities are to address the problem of money laundering, but when they do, find themselves constrained in certain ways. And I'll get to some of the details on that. But basically, I've been practicing law here in Vancouver for almost 100 years now. And my practice, much to the chagrin of family and former spouses, has been to act for plaintiffs against large institutions like banks and insurance companies and governments. So I'm very familiar with the whole David Goliath dynamic. I'm right at home in acting for whistleblowers in that context. And it's my thinking that the status of whistleblower is really not a binary concept at all. There are elements of whistleblowing involved in many of the cases I've acted on over the years. People who've spoken out against power and have been punished for it in various ways. Some by reason of their personal interests being compromised, some because of their view of a greater public interest. And in the context of these two fellows who came forward on the money laundering, they had very comfortable careers. They were on a solid footing with their respective employers. They had stable lives in many ways, but they just couldn't stay quiet on what they had observed. So really with them, the public interest became paramount. They felt that they weren't going to submit to the conflict of interest that seemed to prevail over most people. In other words, they weren't going to let their own personal self-interest in advancing their own careers keep them quiet from what they observed. And I think that's classic sort of mentality of a whistleblower, somebody who thinks beyond themselves and is willing to pay a price. And so what we did with the money laundering thing here in BC is an inquiry was struck, a public inquiry was struck in the spring of 2019 after many months of publicity in the media, which was caused to a large part by the information provided to the media by my clients. Both of my clients had made efforts internally to have the problems they recognized responded to, and both of my clients were stifled and somewhat stigmatized in the efforts they were making internally. So both of them went public, and it was really the pressure caused by the publicity that motivated the Attorney General of BC to announce the instigation of this Commission of Inquiry. It was to review the extent, growth, and evolution of methods of money laundering in BC, the acts or omissions of responsible regulatory agencies, the scope and effectiveness of anti-money laundering powers, the barriers to effective law enforcement. when both my clients were personally very, very conflicted by what they were doing. One of my clients, the former NCO of IGET, which is an acronym that's for the an RCMP unit called the Integrated Illegal Gaming Enforcement. He was an individual with 29 years of service with the RCMP by the time he quit. Several years before he quit, he was transferred from a career in organized crime to this relatively new unit, which was intended to investigate illegal gaming outside of the casinos. But it became quickly apparent to him that since millions and millions of dollars of cash were being laundered through the casinos every month, there was an overlap between what was happening within the casinos and what he was supposed to be confined to investigate. And it was impossible for him to ignore this tremendous overlap, and from his efforts to address what he saw as being the use of the casinos by organized crime, a bit of a turf war evolved between the provincial agency that was to investigate what's happened in the casinos to what my client, Sergeant Pinnock, was to investigate. So that became a bit of a turf war, and it became apparent to my client that he was being regarded as a real troublemaker, somebody who was interfering with what was happening in the casinos. The government, of course, as I said, being in a huge conflict of interest because so much of the revenues from the casinos was as a result of the organized crime that Sergeant Pinnock wished to have investigated. So that blew up into an ongoing problem to the degree that Mr. Pinnock, Sergeant Pinnock, was basically forced to resign from the RCMP. He had just before he did leave the force, he had gone public, and that was probably helped usher him out the door in the minds of the command here in BC. But what he told the public was that a number of things, like for the police not to have well-resourced law enforcement units dedicated to casino environments is very short-sighted in his opinion. And he went on to the reasons why in his view, this was all connected to thousands of fentanyl deaths in BC, to the impact on the Lower Mainland housing market, adverse implications of governmental inattention to the literally billions of dollars from offshore that were coming into Canada in ways that the casinos were very active in helping to launder. So that was one of my clients. He was, as I say, he was with the RCMP, and he came forward with his observations completely independently of Sergeant Pinnock. Was a gentleman named Ross Alderson, who was the director of anti-money laundering at the BC Lottery Corporation. His observations were very similar to those of Sergeant Pinnock. There was a culture within the casino that inhibited his ability to take meaningful steps against what he observed was happening. As he said, as some of his evidence said, his conscience told him the public needed to know because public pressure through about these well, he says the only way governments make ethical decisions in his experience was by going to the public, and the public would then, through the media exposure, put pressure for some meaningful changes. And so his experience was that the only recourse he had was to go public. So that's what he did. And it was a few months after the W5 had done a expose on dirty money in BC, and Mr. Alderson was the witness who came forward on that. And it was his first he had leaked things to a fellow named Sam Cooper, whose book is out now and is quite well known as exposing the industry of money laundering in BC. He had, before going on W5, been doing surreptitious leaking to Sam. But for many of the same reasons, both with Ross and with Fred, these gentlemen were just unable to put their own self-interest ahead of what they saw as being the public interest. Their own career paths were not as important to them as they felt the public interest to be in exposing what they saw was going on. So they came forward, and anyway, as a result of the publicity that they were able to generate, the commission was struck. I just want to, I know I'm kind of short on time, so
I'll give you one more, give you 1 minute.
1 minute. Oh God.
1 minute.
Well, I had, what I had meant to do is talk about the commission itself, because from a lawyer's perspective, things like procedural fairness, natural justice matter a great deal. We applied for standing. Standing means the right to participate in the hearing rather than just be called as a witness, the right to be actively a participant by the ability to cross-examine other witnesses, by getting all disclosure of all the documents, by being able to tender documents yourself, creating a level playing field. What had happened at the commission, and it was a great concern of mine, and I made it very clear to the commission, that I thought the commission's integrity is at stake if it makes findings to the discredit of the whistleblowers, and how it treats whistleblowers is very much going to affect the public's view of what this commission does. But I said there has to be a level playing field. There should be resources allocated to whistleblowers who can then more meaningfully participate in an inquiry. Otherwise, the evidence that is adduced from them is at the mercy of commission counsel, who will decide what to ask and which documents to put to them. There were thousands of pages of documents that never got entered as exhibits in the commission because neither Fred Pinnock or Ross Alderson had counsel capable of participating the way some of the other participants were. And I'm sorry if I'm rushing a bit, but at the end of the day, we don't know what Austin Cullen, he's the commissioner, a very fine and ethical gentleman, and I'm sure he's going to do a good job. But at the end of the day, how deep he's able to dig on what really matters, I think very much depends on how he treats the whistleblowers. And I'll just leave with this, that when I closed my submissions with Austin Cullen, I said, unlike many of the participants, the well-funded participants, the whistleblowers have no dog in the fight. They have no reason to come forward. They've come forward at great expense, at threats to their personal safety, stress, stigmatization, defamation, you name it, the whole slew is what they've been prepared to suffer to come forward. They have no dog in the fight. They have no reason to mislead the commission. And so when it gets down to who said what, when, that's got to be the starting point. My clients had no reason to fudge the truth. And we know that many of the others, whether they're accused of inattention or sometimes even worse, do have reasons, and well-funded reasons, to not be absolutely forthright with the commission. So that was a sort of a message I tried to really drive home with the commission. And I've got a lot more to say, but I'm way over time. So thank you for letting me ramble.
Thank you, Paul. And we'll come back to you again. And thank you for continuing to paint this picture that is, I think, so overwhelming, but so there are some massive forces and opaque things and big things happening. But then to talk a bit about the practical pieces and the technical bits of the law that the lawyers are trying to navigate to do this work. And it's fascinating because it's not easy to wrestle any of that into 10 minutes. And we'll move on to Carolyn, and then we'll come back through and come back to everyone again. Carolyn?
Well, thank you, Heather, and it's a pleasure to be on this panel with our Paul and Kelly. And I come from a very different perspective, which is three-pronged, if you like, which is as an investigations practitioner for over 30 years. And because I specialise in sexual exploitation and abuse, the gathering of circumstantial evidence is something that I'm trained in. And the whistleblowing and garnering evidence on retaliation is the business of circumstantial evidence. So it's never direct, you know, it's always behind the scenes hearsay, and it requires a certain training, if you like. I also research the subject because I was a whistleblower myself with the United Nations, and I was subject to 15 years of litigation. I think it was the longest litigation. And as we've just heard from Paul, it was the Canadian taxpayer and that footed the bill for that litigation, which ultimately resulted in an apology. If we'd had a fund for me to have counsel, well then it might have evened the playing field a little bit, because there really wasn't any motivation other than to tell the truth. And in fact, with the United Nations, you are required as a United Nations civil servant to report. And if you don't, that is considered an offence. But what we have is a system which is in place, which is not independent, which is both the judge and the party to litigation, and is unfair to its core. So maybe if I just pop some slides on, Avi, if you're there, I can just talk you through some of my observations of what goes on in the mind of the whistleblower. So if we can move to the first slide. So this is the whistleblower. So when I'm doing my investigations and I want to find facts, I need my witnesses, as do the litigators. And to get good evidence, you need people to be in a space where they feel safe to speak about the truth. And as we've heard throughout the conference and tonight, we have systems in place, but as we can see from the bridge and where the crocodiles are, it's often not a comfortable place to be, because people don't know the system. They often don't know where to report and who they can trust. And they look very carefully at how whistleblowers have been treated in the past in their own systems. And that is not a particularly happy story in most cases. So Avi, the next slide, please. So what's going on in the mind of the whistleblower is quite interesting. They're often saying, well, can I make a difference? Should it be me that says it? I won't say anything. This is wrong, or I should do something. But actually, the ultimate sanction for any whistleblower is that of exclusion, because nobody wants to be excluded by their bosses, by their fellow colleagues. And for those of you, I've had a little look into the neuroscience of whistleblowing here, and we have something in the back of our brains here called the dorsal anterior cingulate gyrus. And it is the pathway of physical pain is the same pathway for the pain of social exclusion. So it's a very powerful imperative of an employer or a community to exclude someone. And if people think they're going to be excluded or not spoken to or maybe fired, they are less likely to report. So I think the next slide, please, Avi. So the heart of the issue is that we don't have safe speak-up cultures. People don't speak up. My role as an investigator is really to try to build trust and to let them or find ways that they can give the information that's needed confidentially. But sometimes I'm not able to identify them. And of course, as the litigators that are here know, that's a problem when you get into a court of law, because you can't have an anonymous person standing up in a court of law. So, you know, this is it's in the interest of those that have the power to make sure that people don't actually feel safe to speak up. Although lip service is given to it, and certainly in the United Nations, in fact, the Secretary General Guterres said in 2017 he would make it his priority to improve the appalling record of the UN Ethics Office in implementing whistleblower protection. But actually, when you take a closer look at the system is built, or interpreting the margin of protection is so difficult to meet that standard that most whistleblowers are actually excluded from protection. So the next slide, or the last slide, please, Avi, is that the crux of the issue, or the points that I really want to make, is that we have the laws, the institutions, and the expertise, but what is missing, and Paul Champ addressed this, is the political will re-accountability. And we heard him speak about the elites that work together, and it's, at the crux of it, the media playing a very important part in shining the light, but in super sensitive cases, and we find this in Switzerland in particular, that editorial control is exercised. Even when there's a good story, the editor says no way, because the actors, for example, Nestle in Switzerland, have got the power to silence, the media. And there's another insidious practice in Switzerland, which is of suing whistleblowers for defamation. And that is a particular problem germane to Switzerland. And so many Swiss whistleblowers are silenced because they have to face, there's litigation, and litigation in Switzerland is super, super expensive. And that is another major imperative to reporting. So just to sum up the little balloon here, is that the issues with working with whistleblowers is that there is often a failure to report for all the reasons that I've outlined, a major fear of reprisal because whistleblower protection does not work, especially in the United Nations. I'm just finishing up a book with Alexis Bushnell, and several UN whistleblowers, which are basically their narratives about their own experience. And because taxpayers ultimately fund the United Nations, I really think it would be wonderful to have an inquiry into why this is happening in the very institution which is the guardian of human rights. So I'll leave you with that thought, and I hope that I'm within time, Heather.
You absolutely are. Thank you for that, and for continuing to paint another piece of this picture and another layer around another layer of this issue. And we'll pass it on to Kelly, and then we'll come back around. Thanks.
Okay, thanks very much, Heather. And thanks, Pamela and Paloma and everyone with the Canadian Whistleblowing Research Society for inviting me to be part of this discussion. I also want to thank all the speakers who have participated throughout the conference, because I certainly have enjoyed your wisdom and your passion. So thank you for that. I thought I'd speak just for a minute about whistleblowing from the employee perspective. And in my practice, I represent whistleblowers in human rights and other employment circumstances, as well as some non-whistleblowers, or sorry, not non-employee whistleblowers. I think that many times employee whistleblowers believe they have protections that don't really exist, or at least pragmatically don't exist. And so the law, in my view, piles up pretty quickly against employee whistleblowers. Before I go any further, I'll just mention this. Please don't consider anything I say as legal advice, first, because I haven't obviously taken your case into account. Second, I could easily be wrong. So we'll just leave it at that. Here are some of the things that I think pile up against employee whistleblowers. First, employees often enter into contracts that contain express terms that dissuade against providing information from inside their organization. So confidentiality and non-disclosure agreements, non-disparagement terms, and even arbitration provisions that would ultimately drive employees toward arbitrating disputes as opposed to proceeding in a different fashion like whistleblowing. And you might think to yourself, well, sure, those obligations might exist, but isn't the higher obligation to blow the whistle on perceived wrongdoing? I think that for some employees, there is a crisis of conscience that arises when they've made an obligation to their employer. And secondly, I think that, pragmatically, there is a legal risk that arises from breaching an employment contract, including termination of employment. Beyond expressed contractual terms, there are also ancillary terms like organizational policies that can also encourage or require confidentiality, and in some instances demand that no criticism be made of an organization. Here in New Brunswick, the Teachers Association actually has a code of conduct that discourages teachers from criticizing one another and the administration. And that, of course, has a chilling effect on whistleblowing. And then just to go further, employees who are contemplating the idea of blowing the whistle should also consider implied contractual terms. And these have existed for centuries and include the concept of serving your employer faithfully, advancing your employer's interests, maintaining confidentiality, not defaming co-workers, and then there's a boomerang implied contractual term, which could be that an employee who has watched wrongdoing take place for a period of time and has been too fearful to raise it, and who later reaches a breaking point to decide they are going to blow the whistle, or that they want to consider blowing the whistle, now have to wonder what the ramification will be that they're blowing the whistle, but doing so late in the game, because the question will be, how come you didn't come forward sooner? So these are all practical considerations for employees. And I thought I would show you some wording that comes from a decision issued by the British Columbia Workers' Compensation Appeals Tribunal. And it was a case arising from a whistleblowing circumstances that resulted in a psychological injury. But look at what the tribunal wrote. Alleging discriminatory action does not operate as some sort of charm or incantation which operates to protect anyone who alleges it. And further, the tribunal said the employer's decision to reprimand and dismiss the worker were not motivated, even in part, by his complaints of bullying and harassment, but were motivated by his refusal to follow managerial direction. Paul alluded to, this kind of mindset. I should say Paul Champ alluded to this kind of mindset when he pointed out that there are no findings of reprisal in the federal sector. So those are some of the things employees are up against. And this statistic that comes from Patricia Patrick, it's an American statistic, but anecdotally, it aligns with my experience, and I'd be interested in hearing the experiences of the others. But whistleblowers have to expect to be in for a rough ride. Patricia Patrick found that 74% of the whistleblower cases that she examined in the US resulted in employee terminations of the whistleblowers. 15% resulted in poor evaluations, and then a combined 11% in suspensions and transfers. In other words, nothing good happened for whistleblowers. And I think that's probably true. I think it's true as well that the whistleblowing laws that employees think exist are in many instances toothless tigers. I think that we would all like to believe that the legislation is solid and reliable, but in practice, I think there are many instances where it isn't, and it's complicated. And again, I think this is an important point. Heather brought up that as a lawyer, she was, in a position to better navigate the system. But, consider the plight of people whose expertise lies elsewhere than in the law. Trying to navigate a system that really doesn't provide the kind of protection that we might think is, I believe, challenging, frustrating, upsetting, and I think that it can easily cause, significant hardship. In my jurisdictions of New Brunswick and Nova Scotia, it's possible to invoke all of these different sort of loose, ill-fitting remedies in a whistleblower case. So use of public interest disclosure legislation, occupational health and safety legislation, employment standards legislation, the common law, or for employees who are employed by government public service legislation, human rights law, and even right to information legislation. But it's like a patchwork quilt as opposed to a comprehensive and sensible system of protection. So where does that leave us? In my mind, first, it's important for any would-be whistleblower or employee whistleblower particularly to understand that it's not an easy path forward for you. Secondly, don't misapprehend the extent and the power of the legislative provisions that are said to apply. I think that would be a tragic mistake. And that's not to say you wouldn't go ahead and blow the whistle, but it's like preparing to run a marathon. If anyone tells you it's going to be easy, they're not telling you the truth. I think another thing to consider, as a systemic response is, should we strengthen and simplify legislation? I think the answer is yes. But I also think, and this will sound naive on my part, but I've thought it through, I think we should consider changing the game when it's possible. And what I mean by that is consider adopting a more humble and forgiving response to misconduct. If you consider it, at least in my experience, what happens is that, the problem for many whistleblowers is that the stakes that are presented to the perpetrator or the wrongdoer are so high that the choice available to them is really only to act aggressively and to respond with an iron fist. And again, I say all of that knowing that it sounds naive, but wanted to say it anyway. Last thing, if you don't mind, I want to read to you just really quickly an excerpt from Daniel Markovitz's book. This came to my mind when Paul Champ was speaking about whistleblowers wanting to achieve justice when they blow the whistle and being disappointed by the system many times. Daniel Markovitz, who teaches at Yale, wrote, lawyers and the legal process support transformations in disputes that create ends so that clients come to want, or at least to accept, what the system is prepared to deliver. And he goes on to say the legal process, to put it bluntly, secures peace only by abandoning justice. Now that, again, sounds a little bit dismal, but that could be true. So thanks, Heather.
Thanks, Kelly. I think it's more things that are depressing, but somehow soothing or reassuring, that you know, I said to Paul Jaffe yesterday or the day before that I felt a bit naive as a lawyer in some ways, that I was a bit of a Pollyanna going into the process. Because I thought I should have known better. I thought I should have, even though I was able to navigate, I thought that I should have perhaps been able to navigate better. So it's always reassuring, I think, and for everyone to know that it's not easy. It's not easy to navigate, and the system is not really set up for success for whistleblowers, but this is really helpful. And so, as I said, if we could run back through the speakers and give everyone a chance to, panelists, to pick up on something someone else has said or pose a question to another panelist. Maybe we'll take 2 or 3 minutes for each. And Paul Champ, if we could start with you.
So I'm just taking a look at some of the questions that are also coming in online. There's some good ones. One person's asked the question, do any of the panelists have any ideas how to change this culture to be less polite, thereby being more assertive and holding institutional leaders to account? I think everyone kind of picked up a little bit on my point that there's a bit of a culture of elites trying to protect elites, or I don't even know if I describe in Canada anyway, that's the way I can speak. I don't even know if it's about trying to protect elites, although it could be that far. I think it's just more about politeness. They just feel it's so impolite to point the finger at someone, and you know what I mean? So I don't know what other people think. Like panelists, I don't know how we change it for decision makers, how we make our systems more robust or responsive, because, you know, while we have, you know, a recognition that whistleblowers are so crucial to our society, right? I mean, whistleblowers are a symptom, you know, that show that there's something wrong in the organism, right? And they do put us, they almost always expose some kind of wrongdoing that can make things better. But, you know, in my experience, unfortunately, it remains the case is that the individual whistleblower still ends up suffering and paying a personal cost. And I don't know how we change it. Like we've passed laws, we've adopted laws. You know, there's even a criminal code provision, I'm sure has been discussed at some point in this conference about, you know, an employer cannot threaten dismissal. It's a criminal offense to threaten dismissal, et cetera, for someone who's reported a breach of a statute, et cetera. So the laws are there. I just don't know how we change it culturally. I don't know if anyone else has any thoughts on that.
Paul Jaffe, do you want to pick up on that point or on a different one? Oh, and Paul may have frozen.
I think Paul's
Okay.
muted.
Yes, a generally good plan for me to be muted, but the law is only effective to the degree that a court will enforce it. And all the facts and law in the world makes no difference. You can't fight your way through what happens at the courthouse. And being an institution run by human beings, it's no less imperfect than other institutions, and it's fairly characterized as political at times. There's a culture on the bench that exists by nature of how judges are appointed, where they're appointed from. And it isn't people like whistleblowers who get to choose who are sitting on the bench and who are interpreting the laws and making findings of fact on these cases. So right away, you have to appreciate, in my view, that when you step into a courtroom, you're up against a culture that tends to be predisposed against those who are challenging certain prevailing perspectives. I tell my clients, and Kelly, you ended on this note, it's a legal system, it's not a justice system. All the facts and law in the world makes no difference unless you're able to get from A to B. And in that context, I think it's fair to say there is a culture generally in the courts that's not always friendly to people who rock the boat the way whistleblowers do.
Carolyn,
Heather,
can we go back?
Oh,
Sorry, Kelly. No, go ahead, Kelly.
If I could pick up on that just for a moment, I thought it might be useful for us to defend the law slightly. And I say that first from a position of criticizing it lots of times. I've written a book about this too, but Barack Obama once said that the study of law can be disappointing. It's a matter of applying narrow rules and arcane procedure to an uncooperative reality, a sort of glorified accounting that serves to regulate the affairs of those who have power, and that all too often seeks to explain to those who do not the ultimate wisdom and justness of their condition. But that's not all the law is. The law is also memory. The law also records a long-running conversation, a nation arguing with its conscience. And we've seen our nation argue with its own conscience and amend its laws over time in response to those arguments. I think that here, in the context of whistleblowing, we have an opportunity to argue with our conscience and to amend the structure so that it can be more effective. I honestly think that one way to consider doing that is to reframe the whole question so that it becomes more possible for the alleged perpetrator to embrace the feedback, as opposed to making this a competitive environment where we have a whistleblower on one hand and a respondent on another. I'm not sure that will ever lead us in the direction that we actually need to go. And the reason I say that is because resources will never be apportioned in a way that will create equality in the legal process that is going to follow in a whistleblower case. That just a thought, at least.
Thanks, Kelly. Carolyn?
Yeah, I echo the thoughts about reforming the system. I think we actually have to tear down the litigation system. Does not serve whistleblowers. Point. My case in point. I think we have to take it out of litigation. Given that whistleblowing generally is in the public interest, we do need to allocate resources to a new forum where somebody independent is looking at this issue from outside of traditional structures. We've had two litigators tonight talk about how the system is not serving. In fact, it's more polarizing. And ironically, I had mediation before my during my 15-year litigation, and that actually served to re-traumatize me to dig it all up. So that doesn't work either. It can work in certain cases, but it certainly didn't work in my case because of the violence of the retaliation. And by the way, the UN court did find retaliation in 2013. So it is one of the very few retaliation judgments. But of course, it was appealed, and I ultimately settled. But I think the people around this table and Whistleblower Research Canada are well placed to start thinking about what does a new system look like that's in service to whistleblowers. So I'm for a whole new system to be created. But of course, you come up again, the people with the power, the ones that make the laws, and is it in their interest to have something which they can't control? We have to remember the reason that Julian Assange is where he is today is because he trumped editorial control and he couldn't be controlled. So he had to be taken out.
Thank you, Carolyn. I keep forgetting that I'm moderating because I'm listening and I'm so interested in what I'm hearing, and so I'm relating to so much. But maybe we can move to there are quite a few questions in the Q&A. One of the first ones that's in the Q&A is from Carol Boydell, which sometimes whistleblowers want to make a disclosure, but they're counseled to report wrongdoing under laws that are different from standalone whistleblower legislation, so such as labor, occupational health and safety laws, which sometimes tend to offer, other fewer, to offer fewer protections. What do you think of this practice in terms of properly protecting the whistleblower? Given maybe it was your slide, Kelly, that shows the number of whistleblowers who were either fired or I'm not sure has anybody had any success or found other legislation other than express whistleblower protection laws where people do find some protection. Has anyone had any success under other types of legislation?
Sure, if you don't mind, I'll take a stab at that, Heather. I think that occupational health and safety legislation typically does contain reprisal provisions that are just emerging in some jurisdictions as opportunities for for seeking remedies when there is reprisal related to whistleblowing in at least the health and safety context. But I think Carol is raising a really good point that so many of these cases are very difficult because there aren't specific legislative responses to protect whistleblowers. I don't know if the Pauls agree with that, but that's my thought.
I don't know, am I muted? No, okay. One thing that comes to mind is potentially applicable to this is there's this whole new area of law called anti-SLAPP, strategic litigation against public participation, and it's initially intended to address libel cases where people speak out on matters of public interest and they get put through the litigation process as a way to punish and silence people who speak out on things. But it has grown to a more expansive application, which would include situations where people are being taken to task for having publicly disclosed something. So it could be in an employment case. I recently did one involving a school board trustee who allegedly breached the School Act, but just under the surface was the fact that he had expressed opinions on a matter of controversy and his adversaries were out to get him. So they used a pretext of ethical breaches of the School Act. And the court concluded that really underneath this was this other debate. It was a matter of public interest. He had spoken out and litigation was being used to punish him. I see an application of that general area of the law. It's a fairly recent one in Canada, but it's growing as coming to the assistance of people who are being targeted with reprisals. Certainly anything in the court that does that, I think could be met quite effectively with applications under this new kind of legislation.
Anyone else on that one, or will we move to the next question? Fine, I'll go then. Navneet Johal asks, in Ontario, the Integrity Commissioner is precluded under the Public Service of Ontario Act from accepting jurisdiction over allegations of wrongdoing if the subject matter of the disclosure is an employment or labor relations matter that could be dealt with through dispute resolution mechanisms. This is a large barrier as the majority of whistleblowing cases are in relation to these types of matters. Is this the same in your respective provinces? I can say that I did face, when I filed, just as my own, I'll tell you, for MBC, that when I, if you fire a lawyer at the beginning of COVID, I had lots of time to arm every gun in the armory. So I spent some time looking for all sorts of avenues, and I tried the Ombuds office in BC and was faced exactly with that immediate, oh, no, you'll be able to deal with that through that's a matter we're not going to get involved in. So I had to find a different angle. I had to refile, I think, 3 times to get them to actually process or take a complaint forward to say that I'm not complaining about me. I'm complaining about this wrongdoing. This is not about me. Try this. So I found a different way to because I had some time because of COVID. Does anyone else have a thought on that from their jurisdiction?
I think
If
that.
oh,
sorry, go ahead, Paul. No, you go ahead, Paul.
I was just going to make one point on that. When I was saying earlier about how the employers will litigate these cases very aggressively, One of the ways that they will usually try to litigate very aggressively is to fight you around forum. Like, where are you? Oh, you should have complained under this statute or that statute, this statute, and you're before the wrong forum. And I'll say, and that's a perpetual problem. And, you know, I see clients, sometimes they get all caught up in these procedural wranglings, and then there'll be a judicial review, and it all just, it distracts from the merits of the actual case. And, you know, I'll say this, I don't like those kinds of provisions. Like, I think the exclusive jurisdiction model, like for Canadian lawyers or others that are following this, we have a presumption from the Supreme Court of Canada that we have bodies or statutory mechanisms, that there should be an exclusive jurisdiction over, you know, the one process should be the one that's followed to the exclusion of others. I think that's a real problem. I think that to promote access to justice, you know, if there should be recognized there's concurrent jurisdiction. So if you've got one process, whether it's the courts or some statute or some complaint mechanism where you've raised your issue and it can fall under that, you shouldn't be kicked out because it said, oh, well, but you could complain under this one. I think that ends up being a real barrier to justice. You know, that arises in other contexts. I regret to say I was in the Supreme Court of Canada representing someone just not that long ago on the exclusive jurisdiction between human rights tribunals and labor arbitrators. And it has to be one or the other, which that just makes no sense to me. I think it should be, you know, okay, this is the path you've chosen. The person that's the victim or the complainant has chosen this process. Well, then that's fine. As long as they're not abusive and they're trying to ride two horses at the same time, there shouldn't be any problem with concurrent jurisdiction. Because I can tell you, I've seen that club of like exclusive jurisdiction used again and again and again against whistleblowers, and it's a real problem.
If I could take a crack at that one too, please, Heather. I think Paul's exactly right. I think that too many litigants end up mired in procedural wrangling that can be exhausting and I think just completely deflating. And that's prior to ever getting to the substantive issues. In fact, right now I have a case involving a whistleblower, and we've filed 5 different claims in 5 different fora. And in each instance, first the employer, as Paul says, raises the argument that none of those forms are correct, which logically makes no sense. But secondly, I think that even the tribunals are inclined to say, well, if there's a claim elsewhere, you should go have your claim heard there. And that's only human nature, isn't it? Because then that tribunal doesn't have the workload, it doesn't have the responsibility, it doesn't have to deal with the mess. And so there tends to be a little bit of handing off.
Thank you, Carolyn or Paul. Jaffe?
Well, I was just going to say, in my particular case, United Nations cases are heard in its own legal jurisdiction. And there's a first instance and then an appeal, of which you have no right to appeal as a whistleblower. So my UNAT appeal based its judgment, or the United Nations appeal, based its judgment on the fact that it said no arguments, it didn't use any of the arguments that were submitted by either side, the first time in legal history, and then made the decision based on something that neither party had advocated for. And they said that because the misconduct had occurred before the ethics office was created, that it would not be receivable. And I see, our systems, it's not just, there's all sorts of trickery in litigation, like non-receivability, the character assassination, the procedural issues, which are used in standard litigation right the way through. And it's the fact that this is going on, as I say, in an organisation which we all pay for as taxpayers, and that is the guardian of human rights, merits the attention of Canada, at least, and all member states.
Thank you. And I wonder if I'll go back to some of the questions, and I would invite any of the panelists as well. If you see a question in the Q&A, there's quite a few in there. If there's something that in particular that you would like to answer, we can go to one of those. I have a quick question too about non-disclosure agreements. And I'm wondering, because I think in particular in the public sector, those are, I mean, they're problematic anyway, but very problematic when you work for a public sector organization, you complain about a public sector organization, taxpayer dollars are used to wear you down and to draw things out, and it's a pretty deep pocket, and then more dollars, and then with public dollars you may settle, you may be paid off with public dollars, and then you can't speak, and so the taxpayers have paid for every step of that. And so I'm wondering if anyone has had any success or sees any hope in having non-disclosure agreements thrown out or tossed out. Any progress? Has anybody challenged one?
There's been a trend, I mean, just in the Me Too movement, to throw out non-disclosure agreements. I've seen that a few cases that have popped up, which is, I mean, one can argue that some of the Me Too movement cases are whistleblowing cases. But I think now that we've got social media, there's less tolerance on the part of the public for the non-disclosure agreements. And so I hope that with the action of civil society that this will change in the future.
Could I say something controversial about that, or maybe controversial? First, Prince Edward Island is legislating against non-disclosure agreements. But second, my worry would be that we should think through the pros and cons of non-disclosure agreements before we throw them to the wind, I think, because, and the reason I say that is because I'm not always convinced that non-disclosure agreements are as bad as people think they are. I think we've created a narrative that they're always bad. I don't think they are always bad. And secondly, I think that, you know, for a victim, the question in my mind becomes, okay, if you're not going to exchange something in terms of a resolution, are you going to get the best resolution that you could otherwise achieve? I'm not sure people end up happy in the end by retaining their right to talk about their case. And I'm not sure that's what the law is trying to accomplish, but I'd be interested to hear what others say.
Personally, I think whistleblower cases should be a matter of public record. I mean, they're in the national interest, they're often at the expense of the taxpayer. And obviously, if there's a shared mutual interest in not disclosing certain aspects, which there often are, then that's fair enough. But it's the gagging about your story which has you walking on hot coals, I imagine, when you have a right to express yourself about your experience.
Yeah, if I could, Kelly makes a great point. I have to confess, I'm a little bit ambivalent about non-disclosure agreements because there's pros and cons. And I deal with them like not only in the whistleblowing context, but quite frankly, in my practice, more common in the sexual harassment, sexual assault even context. And those are really difficult. I think that Kelly does make an excellent point that if there's not some non-disclosure provision, you're simply not going to get a resolution or not get the best resolution. And that's a problem. But on the other hand, in particular, what Carolyn points out, where someone is handcuffed and gagged, not only over the settlement, but over their own story, that's their personal story. I try to ride the line a little bit. What I try to do is in the non-disclosure, because I've never had a case where there hasn't been well, not never, but once. I've had one recent sexual harassment case where there wasn't a non-disclosure. And no, I apologize. It was non-disclosure on the amount of the settlement. And so getting to what I was going to say is having a non-disclosure about, was there an amount and how much that amount was paid, having non-disclosure over that is acceptable, but a gag that the person can't talk about their story is really problematic, and those should be prohibited. And I think there's still an interest in employers to settling. Like, it's one thing if an employer's paying, $500,000 or $200,000 to make a case go away. I can guarantee you most of those employers will not pay that if they know it's going to be public that they paid that much to make the case go away, for two reasons. One, other people are going to try to demand that from them. And two, because they paid so much, people are going to think there must have been validity to the allegations. And so therefore you won't get a settlement at all. So it's problematic. So I guess if I'd boil it down is I don't like agreeing to where the person is gagged from telling their story. And then the second thing is I hate those automatic clawback provisions where, okay, there's a non-disclosure. You can't disclose there is a settlement. That's fine. But if it's breached, then the employer has to prove, well, what is the harm? What's the quantum or the value of the harm? And usually those damages might not be that much, but sometimes you'll see them where there's an automatic clawback of the entire settlement. I hate those, and I try to fight back on those every single time that I can, but some, often they do get in there. It's really, really tough, that NDA issue.
Thank you all. That was actually really helpful. It's great to sort of it's like everything, there's layers to that conversation and considerations. I think from my perspective, I think about taxpayer dollars in particular and burying abuse of public abuse of public funds or breach of public trust, and that those things then get buried with taxpayer dollars. But obviously there's a whole range of other types of situations where they do make sense. And that you're exactly right, that if you want to move forward and reach a settlement, sometimes they're essential and they can be valuable as well. If there's any more questions in the Q&A, I'm struggling a bit with some of them to find a question in some of them. I think there's a bit of conversation there. If there's anything that anyone would like to pick up on, or I think we're 10 minutes before the end. And so we can also just do another round if there are some closing comments. Do you want to do a quick round? Paul Champ, do you have a few closing comments or?
I guess I would just say this, if I was to be candid. When we talk about whistleblower protection, I just don't know if we can speak in that terms, because I don't think that on any sort of like rational basis that a whistleblower can ever really be protected, or that they come out of it on the other side in a way that they've been properly vindicated or compensated. There is always a cost, a big cost, and a sacrifice. And, the sacrifice for them is their conscience versus all the things that will happen if they lose their job and so on and so forth. I think people, when they make that moral choice or decision to move forward and blow the whistle in some way, don't be too wedded to the idea that there's going to be justice and vindication on the other side of it, other than your own personal conscience, and maybe the respect and admiration of others for you for exposing wrongdoing. Maybe in the media, because legally, you're not going to get, in my experience anyway, the pure vindication or compensation that you deserve. It's such a struggle.
Thank you, Paul Jaffe.
Yeah, I don't have much to add other than I'm very impressed with the discussion, and it's a discussion that I don't think we were lucky enough to have years ago, but better late than never. And the only other thing I'll add is with respect to my experience with the Cullen Commission money laundering thing, and on behalf of a couple whistleblowers, when we applied for standing at the outset, we were met with the response that this is not an adversarial process, and there's a congruence of interests as between what the whistleblowers have brought forward and the purposes of the inquiry, and that all of their evidence would be marshaled through commission counsel, and that the public are well served by this process. I disagree. I think there should have been, and perhaps will be down the road somehow, a resource available to whistleblowers who can somehow qualify for funding. If the commission itself won't accord them with standing that gives them the right to full participation, then there ought to be some other institutional sort of capability to accommodate these folks. They've already paid a huge price. They've probably lost their careers and other consequences. I look back at the Cullen Commission and think it would have been a more productive fact-finding exercise had these folks been better resourced and participating more fully. That didn't happen. So maybe we can evolve in that direction somehow.
Thank you, Paul. Carolyn?
Yeah, absolutely. Echoing that point entirely, that, you know, if we had a system where, you know, even if it was an independent judge who preliminarily reviewed a case, said this looks like it's a bona fide whistleblowing case, and that resources be allocated from a special fund, I think absolutely the path. But one issue, we haven't discussed it tonight, but as I research retaliation, I've become more and more interested in the issue of blacklisting, and the blacklisting of whistleblowers and the losing of their subsequent jobs is really something that I would like to see litigated, because it's one of those circumstantial evidence issues, very, very difficult to get evidence of it. But the more, you know, I learn about it because, you know, people call me and then you track. For example, there's a case, well, the International School of Geneva has some issues with whistleblowing at the moment. And those teachers that have reportedly blown the whistle have subsequently been losing their jobs at different schools, you know, within Switzerland. So what's happening here? Who's responsible? There's more than just the institution responsible. And this question needs light on it. And it's not something that we're evolved enough to be discussing, but I just like all of the panelists and anybody listening to really think about that issue, about the blacklisting. Very insidious, very difficult to find evidence, but definitely in need of litigation, which I rarely advocate for. And thank you for the opportunity to present tonight, Heather and panelists.
Thank you, Carolyn. And Kelly, last
Yeah,
word.
look, okay, well, thanks. This has been really enjoyable. So to Paul, Caroline, Heather, Pamela, thank you very much. I think that in the end, it's important for all of us to recognize that the law is an effective tool in some regards, but it is not completely effective, and it won't solve some of the problems that whistleblowers face. It also will definitely not cure the anxiety, the stress, the strain, and I think the psychological injury that often comes with blowing the whistle. It won't do that, and so we have to look elsewhere.
Thank you, Kelly. And I'll apologize before I close it off to those who have posted questions that we didn't get to. It's always a bit unsatisfying. I know I apologize to those people that we didn't get all the way through. I do want to close by thanking you all, not only for giving us this time on a Saturday, and I know some time in advance to prepare, but to thank you for caring about these issues and paying attention to these issues. It's easy to, I think Paul Champion said at the beginning, to get in problem-solving mode, and lawyers deal with the law. They deal with the law, and you have to be pragmatic and a bit of a cynic and try and get people through situations and get to a solution. But I certainly appreciate, and I know many people do, and I think that everyone should, all citizens of the world should appreciate when people give some time and effort, and particularly when you have the expertise to make a difference, that you are trying to shine a light, that you're taking time to think about these issues and learn about these issues and advocate for people. it makes a huge difference to people to know that people are hearing them and seeing them, and understanding and seeing that they are being harmed, and then recognizing that harm and trying to do something about it. Lawyers who are practicing have a ton of potential to move the needle, not just in where they choose, what they choose to push, and in the conversations that lawyers have amongst themselves when they're both representing clients. And so thank you all very much. And I don't know, I guess I'll give do I give the final word, Pamela and Paloma, to you? This is the last full panel of the day, and I hope that there's a spot for everyone to thank you as well, because I found this last day and a half incredibly helpful and informative. And I don't know if there's a formal place where that gets to happen or if I get the last word, but this organization and Pamela, you in particular, were a huge help to me when I was going through this process. And so I applaud you both for the amount of work that went into this, and Avi for your support. So thank you all so much.